Welcome back, folks, and buckle up, because what you're about to watch is a Michigan courtroom moving at full speed. We've got arraignments, sentencings, and a bond violation all stacked on one docket. This judge isn't wasting a single second. Now the first name up. Mason Kazlowski, 19 years old, and the deal on the table. It's actually more favorable than you might expect. Let's break down why.
All right, we're back on the record, and we'll call People v. Mason Kazlowski. We have an arraignment in 26-7160 FH and a sentencing in 25-7106 FH and pending bond violation. And counsel, you want to state your appearances, please?
No, and I have Mr. Kozlowski, who appears in person and custody to my right.
All right, and for purposes of arraignment, is a forensic center referral requested?
No, Your Honor.
Do you consent to the filing of the amended information for plea taking?
We do.
And do you or your client wish to have the allegations formally read?
No, Your Honor, we would wait.
All right, and I have a plea agreement for pleading guilty to the amended count one, which is the attempt MDOB over 1,000, dismiss the original, restitution 11,600, joint and several, sentence agreement for concurrent with the 7106 and within the guidelines of 0 to 9 months. Is that how you wish to proceed, Mr. Kazlowski?
Yes, sir.
Okay, would you stand and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. Mr. Kazlowski, a guilty plea hearing is an important event. If you have a question, because you give up a lot of rights that you have. So if you have a question, ask. If you need to talk to your attorney, ask. Don't just go along because you don't know what's going on. Let us know if you need a minute. Okay. Now let me explain to you the maximum penalty that you could face for the charge that you're pleading to.
Okay, pause right here, because this moment matters more than most people realize. When a judge reads a defendant their maximum penalties before a guilty plea, that's not a formality, it's a constitutional requirement. It comes from a landmark case, Boykin v. Alabama in 1969, which established that guilty pleas must be knowing, intelligent, and voluntary. If the judge skips this step, the entire plea could be thrown out on appeal. So when you hear the judge carefully walking through every right, that's the system protecting itself and protecting the defendant. Watch how thorough this gets.
That's attempted malicious destruction of a building, $1,000 or more, but less than $20,000. It's a felony punishable by up to 5 years in prison or in the county jail, not more than a year, and or $10,000 or 3 times the value of the property involved, whichever is greater. Do you understand the maximum penalty?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form?
Yes,
And you sign that form?
Yes.
Do you have any questions for me or Mr. Nightingale about any of those rights?
No.
Do you understand if you plead guilty, you give up those rights?
Yes.
Is that what you wish to do today?
Yes.
If I accept that plea, you give up any claim that the plea was caused by threats or by promises not put on the record today. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You'd do that by filing an application. But the types of issues you could raise on appeal after pleading guilty are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir.
All right. Other than the plea agreement as I've outlined, well, do you understand the plea agreement as I outlined for you?
Yes.
Other than that, has anybody promised you anything?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes.
Do you understand that sentence agreement is not binding on me? I don't have to follow it. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that? Now that's unless you engage in some misconduct between now and the sentencing by committing a new crime, violating court orders, anything like that, you would lose the right to withdraw your plea, even if I didn't follow that agreement. Do you understand that?
Yes.
Knowing all this, how do you wish to plead to the amended charge of attempted malicious destruction of building over $1,000?
Guilty.
Mr. Kazlowski, back on February 7th, 2026, were you in Sheboygan County?
Yes.
And were you, along with some other people, at a building on North E Street in the county of Sheboygan?
Yes.
And that property did not belong to that building, did not belong to you, did it?
No.
Did you know who it belonged to?
No.
But you knew it didn't belong to you.
Yes.
And did you, either by yourself or with some people, cause some damage to that building?
Yes.
What is it that you did to cause damage to it?
Destroyed some walls.
Okay. With your fists or feet or with objects or what?
Yes, with objects.
With objects, okay. And you directly participated in that?
Yes.
Do you agree that the amount of damage was $1,000 or more to that building?
Yes.
All right, Mr. Nightingale, you satisfied with that factual basis?
I am, Your Honor. Thank
Mr. Juliet?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
you. No,
And do you believe I've complied with MCR 6.13?
the court has.
Mr. Juliet, do you agree on both questions?
I do.
Mr. Kazlowski, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. Then we can schedule sentencing for July 7th at 10:20. Mr. Nightingale, is it your request to adjourn the pending sentencing to the same date and time?
Yes, Your Honor.
Any objection, Mr. Juliet?
No, Your Honor.
So in 25-7106, that's up for sentencing and bond violation hearing today. We'll continue both the sentencing and the bond violation hearing to the same date, July 7th at 10:20. And in 7160, we'll put it up for sentencing on July 7th at 10:20. And I'll continue to have Mr. Kazlowski held without release until that time. And maybe by then we'll know what's going on with the Emmett County case, and we'll see what's the best solution going forward to get you on a better track than you've been, Mr. Kazlowski, right? Yeah, I mean, I imagine how old are you right now?
19.
There's stuff you want to do other than sitting in jail in Orange, right?
Yes.
Okay. There's a whole bunch of good stuff you can be doing out there, but gotta change the track you've been on. All right, anything further from the defense?
No, Your Honor. Thank you.
Anything further from the people?
No.
And just like that, Mason Kazlowski's arraignment is wrapped up in under 7 minutes. Here's what just happened in plain English. He pleaded guilty to attempted malicious destruction of property over $1,000, avoided the heavier original charge, agreed to $11,600 in restitution, and is looking at 0 to 9 months to be served concurrently with his other case. The judge held him without bond until July 7th and honestly gave him a pretty real talk at the end. He's 19. The system still sees a chance here. Next up, a very different kind of case. Drug vehicle, different defendant, same judge, same measured pace.
All right, we'll see you then, sir.
Thanks, Your Honor.
And then we can call the case we passed earlier, People v. Cherished, Tumadansky, file 26-7134FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, one county prosecutor.
No, and I got Ms. Tumadansky, who appears in person to my.
Okay. We are here for an arraignment, and it looks like 2 show causes. Let's see. For purposes of arraignment, is a forensic center referral requested?
No, Your Honor.
And do you or your client wish to have the allegations read into the record?
No, Your Honor. We waive it this time.
Do you consent to the filing of the amended information for plea taking?
We do.
Alrighty. All right, and Ms. Tumadansky, I see a plea agreement for a guilty plea to count 2, maintaining a drug vehicle, dismissal of count 1 with a sentence agreement of no immediate jail. Do you understand the terms of that plea agreement?
Yes, ma'am.
Is that how you want to proceed today?
Yes.
Can you stand and raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. Ms. Tumadansky, a guilty plea hearing is important. You waive rights that you have, so listen carefully. If you have a question, ask me. We're happy to answer. If you need to talk to your lawyer, you just let us know. We're happy to let you do that. Do you understand that? I have to advise you the maximum penalty for maintaining a drug vehicle. It's a high court misdemeanor. It's punishable by a maximum of 2 years in prison and or a $25,000 fine. Do you understand that? Were you on probation or parole anywhere?
No.
Were you on bond for any other cases at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights form?
Yes.
And you signed that today? Do you have any questions for me or Mr. Nightingale about any of those rights? Do you understand that those list the rights that you have at trial, but if you plead guilty, you won't have a trial. So you give up those rights. Do you understand that?
Yeah.
Is that what you want to do today?
Yes.
Also, if I accept your plea, you give up any claim that the plea was caused by threats or by promises that we don't put on the record. Do you understand that?
Yeah.
And when you plead guilty, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission by filing an application, but the types of issues you could raise on appeal are very limited after you plead guilty. Do you understand that?
Yeah.
All right, that sentence agreement for no immediate jail is not binding on me. The sentencing, if I think Ms. Tumadansky needs jail or prison, then I don't have to stick with that sentence agreement. But if I don't stick with the sentence agreement, you'd be allowed to withdraw your plea. Do you understand that?
And then go to trial.
Yes, yeah.
Okay, yeah.
Now that's unless you violate your bond between now and then, or don't show up for court, or commit a new crime. By that kind of misbehavior, I wouldn't have to follow the sentence agreement, but you would have lost the right to withdraw your plea by that misbehavior. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you?
No.
It's your own free choice to do that.
Yes.
Knowing all this, how do you wish to plead to the charge of maintaining a drug vehicle?
Guilty.
Mr. Nightingale, we're using the greater offense for the predicate.
That's fine.
Ms. Tumadansky, back on November 7th of 2025, were you in Sheboygan County?
What was that?
Back on November 7th of 2025, were you in Sheboygan County?
Yes, sir.
Were you in a vehicle?
Yes.
Did you have some contact with law enforcement?
Yes.
Did they find that you were in possession of a controlled substance, methamphetamine?
Yes.
Did you know that you were in possession of that substance?
Yeah.
And do you have any lawful authority to possess that substance?
No.
Mr. Nightingale, you satisfied?
I am.
Ms. Goodrich?
Yes.
Mr. Nightingale, you aware of any other promises, threats, or inducements?
No, Your Honor.
You believe I complied with MCR 6.302?
The court has.
Ms. Goodrich?
Yes.
All right, Ms. Tumadansky, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So hereby accept the plea. We'll schedule sentencing for July 7th at 10:40 in the morning. You'll have to cooperate with a pre-sentence report. We also have a couple show causes where it's alleged that you're in contempt of the court for violating your bond for missing tests and calls. There's two of those show causes, but they basically allege the same thing, that you just haven't been testing. You have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of Mr. Nightingale at any such hearing. And you can present evidence in your own defense. Do you understand that?
Yes.
If I find you to be in contempt, I could put you in jail for 93 days and or fine you up to $7,500. Also, if you're not complying with the conditions of your bond, I can revoke that bond. Do you understand that? All right, Mr. Nightingale, you want me to set this for a status conference on that at the same date and time? Okay, we'll just do that. Now, I guess, Ms. Goodrich, given the sentence agreement, any objection to continuing bond at this point with some redirection here?
Do you know if a prescription was filed for the positive?
I don't know.
No.
Okay. All right. Any objection to continuation of bond?
No objection.
Okay, I'm going to continue bond at this time, Ms. Tumadansky, but you have to comply with the testing. Okay. If you have any questions about that, you need to be talking to Mr. Nightingale right away. Now, you just entered a plea to a lesser charge and also an agreement for no jail. But if you fail to test tomorrow, or you test positive tomorrow, that agreement goes away. You understand that? And given that we've had some bond issues with you, if I see a positive or missed test from you starting now, I'll just sign a warrant for your arrest. You understand that? Do you have any questions you want to talk to Mr. Nightingale about before you leave here today? Do you know what you're supposed to do to comply with the drug testing requirements? If you have any prescriptions for anything that would be on that list, You want to make sure you get a copy of that to Mr. Nightingale, so we don't get you arrested on a warrant by mistake. You understand that?
Yes.
All right. Anything further, Mr. Nightingale?
No, Your Honor, thank you.
Mr. Rich?
Okay, good.
Okay, we'll see you then.
So I believe the court wants me to probably step back at this point.
Hold this. Okay, we can call next. People be Ashton Moxlow. This is file 23-6743 FC for probation violation sentencing. Counsel, you want to state your appearances, please?
Lisa Goodrich, Wayne County Prosecutor.
Liz Elliott on behalf of Ashton Moxlow, who sits at council table to my right.
All right. I have had a chance to review the probation violation report as well as an updated mitigation memorandum submitted by defense counsel. Ms. Elliott, have you had a chance to review the probation violation report with your client?
I have, Your Honor.
Any additions, corrections?
The only correction would be in terms of jail time. The original report anticipated a sentencing date of April 26th or 28th. I crossed it out.
Yeah, I've got 13 more days on that. Then, because it got adjourned till now then.
Okay,
Sound right?
yes.
The other thing too is if we revoke his probation, as I understand it, the probation violation report gave him did not include the good time credits, but
That's
on a
correct.
probation violation, we would have to give him the good time credits, which would be an additional 60 days. So I had with that, if we were to revoke and commit, I've got him at 507 days that he'd be entitled to legally.
That's the number I reached.
Okay, all right. Any other additions, corrections?
No, Your Honor.
Any from the people?
No, Your Honor.
All right, any allocution you wish to make, Ms. Allen?
Yes, Your Honor, thank you. Your Honor, Mr. Moxlow wants you to know that he does have family support. They're watching on YouTube. They couldn't make the trip here. It's quite a distance for them. On the underlying offense, Mr. Moxlow was sentenced to a year in jail, was released on probation when this offense occurred. Up until the point that this offense occurred, he was fully compliant on probation. He was living with one set of grandparents. There were some family issues that came up that caused another family member to move into the house. So his probation agent said, "You can't be here." And within a matter of hours, Mr. Moxlow relocated to Frankfurt from Traverse City with his other set of grandparents. He got a new job. He was working on his high school diploma, and he had engaged in some counseling. So for all intents and purposes, he was doing well on probation when this offense occurred. Mr. Moxlow was 19 years old. He's young. The underlying offense occurred when he was 17 years old. He has a job waiting for him if this court decides to release him. Also, on the probation violation, it actually occurred in Benzie County. He pled guilty. He was sentenced on that file. He was given fines and costs and 12 months of probation. So in the event that this court decides to release Mr. Moxlow, he still has 12 months of probation ahead of him. So he has supervision if he's released. Our position, Your Honor, is that it's our job to make sure that there's not further offenses, and we send a message to the community. Mr. Moxlow's been in jail since December. He's got 507 days worth of credit. I would say that the consequence that Mr. Moxlow has had for the operating while intoxicated, he pled to an impaired, has been met. Okay, that will ensure that he doesn't come back before the court. So that goal has been met. The trauma of prison and that environment will only layer more trauma into Mr. Moxlow's life. And he's already, the mitigation report sets forth certain events that have taken place, and he's already got layers of trauma to work through, and that would just add several more layers to it. I don't know that that would have him come out a better person than he stands today. He has a better chance of coming out better than he stands today with community supervision through Benzie County for the next 12 months to ensure that he remains a law-abiding citizen. One of the things that Mr. Moxlow has said to me is that he's very remorseful for his actions that bring him here. He understands that he should have and could have made a better choice that day. The mitigation memo talks about substance use. It's not even something that he's ever really had an issue with. This was kind of an isolated incident. He had a dispute where a long-term friendship ended. He was distraught and he didn't use the tools that he had, and he made a bad choice. He knows that now. He's done significant time in jail, and he's vowed that he will use the tools that he has and continue to work on himself so that he doesn't find himself in this position again. We're asking the court to follow the recommendation and give him credit for time served, discharge him as unsuccessful, and then allow him to serve his probationary term in Benzie County, get back to work, get back to his education, and get back to his therapy so that we don't see him in this court again. Thank you.
Thank you.
That was a genuinely moving statement from Ashton Moxlow, and defense counsel made a compelling case: young age, family support, watching on YouTube, job waiting, trauma history, isolated substance incident. On paper, it almost sounds like a second chance story. But here's the thing the prosecutor is about to remind everyone in that courtroom and watching at home context is everything in sentencing. What brought Ashton to probation in the first place? That's the question that's about to reframe this entire hearing. Get ready, because this is where the tone shifts completely.
Mr. Moxlow, it's not required you to say anything today, but you're welcome to. Is there anything you want to tell me or no?
Yes, Your Honor.
Go ahead.
First off, I want to apologize for showing back up in your courtroom, even though you gave me a chance and I screwed it up. Made a horrible decision to drink. I sat here and realized, thought about what I did. I could have hurt myself, I could have hurt others. I have caused more stuff for my family to go through. And sitting in here this time, I've actually talked to other inmates and got their, their outlook on life and what they have done. And I don't want to see myself in their shoes down the road. There it is. I want to turn my life around. I want to keep going on the straight path that I've been going on. I want to continue my education, get my high school diploma, and hopefully enter a trade program, get a trade diploma. I thank you for your time, Your Honor.
All right, thank you.
Yes, sir.
Ms. Goodrich, any recommendations from the people?
Oh, yes, thank you, Your Honor. We're here on a probation violation. I think it's important to remember what originally led us to have him on probation. He was given a second chance after some pretty violent acts towards a relative that involved holding her down, pushing her, putting his hand over her mouth during repeated sexual assaults, told her he would kill her if she told anyone. In reading the mitigation memo, I didn't see anything addressing these violent acts that he did, these violent behaviors that he exhibited. It was, oh, he had a poor childhood, oh, maybe he has some mental health illnesses, but nothing related to addressing why he came to be on probation. It also kind of made him sound like the victim. That I think even one line I noted said that his education was interrupted by the criminal justice system. Well, it was interrupted due to his decisions and his actions. He wasn't some passive victim where somebody came in and threw him in the criminal justice system. He was given a second chance due to his young age after all of that, and used that second chance at 19 years old to drink alcohol when he's clearly underage, to drive when he had no driver's license, and then to drink and drive. He was caught while speeding. He was 2 times the legal limit, and this was all while he was on felony probation for the second chance. I think that top of the guidelines at this point is appropriate at 24 months due to the public safety concerns of having Ashton in the community. Thank you.
All right, well, Mr. Moxlow, no, you're here today for a probation violation. The conduct that was the violation was the drinking and driving offense in Benzie County. But what that means then is we can go back and look at, okay, you didn't do real well on probation then by catching a new crime. And then you can be sentenced, on the original crime again, right? And when we were here for that original crime, that was, you got a fantastic outcome, I think, because you were 17 at the time of the offense. You were charged as an adult by the prosecutor, as was authorized by law, but you got a different outcome than, say, a 30-year-old would have gotten, right? It was a CSC offense. It was pled down to an attempted child abuse second degree with a 5-year statutory maximum. The guidelines, even at that reduction, were 12 to 24 months, which means even with that reduction, you stood at sentencing where a year in jail was the best you could hope for with probation. And you could have gone to prison that day. And there was a good argument for that, especially when we take into account that was your second sexual offense that you'd committed. One had occurred in the juvenile court system, and then a second offense that brought you into the adult court system. So then you get the probationary term, and then while you're on probation, you commit a new crime. It's very difficult to know what to do. I mean, your attorney has explained, a lot of good reasons why, why maybe we shouldn't send you to prison today. The prosecutor has given lots of good reasons why you should go to prison today. And frankly, your behavior on probation by committing a new crime would allow me to, that's not taken into account in those guidelines at 12 to 24 months. It'd be a legally well-supported, for example, today to give you 3 or 4 years in prison, and you get credit for almost 17 months. By my count, like 16, almost 17 months credit already at 507 days. And the prosecutor's not asking for me to exceed the guidelines. I really can't find any fault with what the prosecutor's arguing here today. And it's taking everything into account. It still is a fairly measured response to what has happened. So I think taking all those things into account, I'm going to revoke your probation, Mr. Moxlow. And on the charge of attempted child abuse in the second degree, I'm going to commit you to the Michigan Department of Corrections for not less than 2 years nor more than 5 years. I will give you credit for 507 days previously served, including the good time credits from the jail. The fines and costs that were previously assessed, I will reassess in any amounts that remain unpaid. That was $68 in state cost, $130 in crime victims. Those were paid off, right? Okay. There were supervision fees were unpaid, were not paid, but the fines and costs were paid in full. So we won't assess any, or we'll indicate that they have been paid in full on the judgment. All right, and that's within the advisory guidelines. I think it is proportionate to the circumstances of the offense and the offender, given the total information and the fact that it was a second sexual offense.
2 to 5 years in the Michigan Department of Corrections. That's the sentence. And with 507 days of credit, including good time, the judge estimates he'll serve roughly 7 more months before his first parole eligibility. Now here's what makes this sentencing legally significant. The judge went above the standard guideline range of 12 to 24 months and explicitly explained why the new crime committed while on felony probation, combined with the fact that this was his second sexual offense. That explanation isn't just narrative, it's legally required. Under Michigan law, departures from guidelines must be justified on the record. The judge did exactly that. Whether you agree with the outcome or not, the procedural foundation here is solid.
So, Mr. Moxlow, that's the sentence of the court. If you wish to file an appeal, you can do so by filing an application to the Court of Appeals. If you want a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper explaining that process. Ask you to initial 1 copy for us, so we have a record we gave it to you. The other one's for you to fill out if you wish to take an appeal. With the credit to which you're entitled, you'll probably end up doing about 7 months in there, okay? And then I presume, unless you misbehave in prison, you'll get paroled at your first bit and be supervised on parole. So good luck to you, Mr. Moxlow. I did prisons union. Good morning. Can you tell me your name?
Harley Price.
Oh, okay. Hold that, Mr. Nightingale. So I did not know she was in the Department of Corrections, or had forgotten if I ever did know.
She was sentenced very swiftly on her other case.
Oh, okay. So this is file 25-7120FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
No, and I got from Ms. Price, who appears in custody in the Department of Corrections here on.
Okay. I've got some pending bond violation issues that I think I'm just going to go ahead and dismiss. She's sitting on a Department of Corrections sentence out of another county. It doesn't make any sense to deal with bond issues here. Ms. Price, I have a plea agreement in front of me for count 1, delivery of the methamphetamine with a dismissal of the drug double enhancement and the remaining counts and the habitual. Is that how you wish to proceed today?
Yes, Your Honor.
All right, would you raise your right hand for me, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. Ms. Price, guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So listen carefully. If you have a question, ask me. If you need to talk to your lawyer, you just say so anytime. The charge of delivery of methamphetamine is a felony punishable by a maximum of 20 years in prison and or a $25,000 fine. Do you understand that?
I do.
Okay, is there any circumstances council's aware of where this would be consecutive to the other case or no?
Not to my knowledge, no.
Okay. All right, and you're going to later file an amended removing the drug double?
Yes.
Okay, you consent to the filing of that? Okay. All right, Ms. Price, did you read and understand the rights listed on the advice of rights form?
Yes, I did.
Do you have any questions for me or your lawyer about any of those rights?
I do not.
Did you give your lawyer permission to sign that form on your behalf?
Yes.
Do you understand if you enter a plea, you won't have a trial and you give up those rights?
Yes.
And is that what you want to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by threats or by promises that aren't put on the record today. Do you understand that?
Yes, Your Honor.
Also, when you enter a guilty plea, in the appeal, You have to get permission to appeal by an application, which they don't have to grant. And if they did grant it, the types of issues that you could raise on an appeal after you plead are very limited, much more limited than if you went to trial and were convicted. Do you understand that?
Yes, Your Honor.
Other than the plea agreement, well, do you understand the terms of the plea agreement that I outlined for you?
Yes, Your Honor.
Other than that plea agreement, has anybody promised you anything to get you to plead guilty?
No,
Has anybody threatened you to make you?
no.
Is it your own free choice to enter that plea?
Yes, it is.
Knowing all that, how do you wish to plead the charge of delivery of methamphetamine?
Guilty.
So Ms. Price, back on July 8th of 2025, were you in Sheboygan County?
Yes,
And did you deliver the controlled substance methamphetamine to another person?
yes,
Did you later find out that person was cooperating informant with law enforcement?
yes, I did.
And did you know that the substance that you were delivering to that person was methamphetamine?
I did.
And you're not a pharmacist or doctor, right? You don't have any authority to dispense that substance, do you?
No,
And did that delivery occur in Sheboygan County?
yes,
Mr. Nightingale, you satisfied the factual basis?
I know.
Ms. Goodrich?
Yes.
Mr. Nightingale, you aware of any other crimes of threats or inducements?
No.
Ms. Goodrich?
No, Your Honor.
And Mr. Nightingale, your judgment, if I complied with 6.302?
The courthouse.
Ms. Goodrich?
Yes.
Ms. Price, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense, so I hereby accept your plea. Do you know what sentence she's sitting on?
I think it's somewhere in the neighborhood of 70 months or something like that, Ms. Price. Can you remind me
51
what your
months.
sentence?
51?
51. Yes,
50, okay. Okay, I guess, what county was that out
Otsego.
of? So we probably just need to do a short little updated report. Would it be fine to set that for June 9th? You'd be able that day?
If I can just check.
We're already getting so many sentencings on the 7th. I don't want to overload you.
No, understood. And she's sitting on no credit time right now. So, yeah, that looks good, Judge. Thank you.
I have the amended, removing the drug double. You consent to that?
Yes, sir.
All right, let's set this for sentencing then on June 9th at 10:30 in the morning. Now, Ms. Price, you have the right to be physically present in court, in the courtroom for your felony sentencing. And if you want to do that, that's no problem. We can do a writ and get you up here. Sometimes people who are already in the Department of Corrections for reasons personal to themselves want to just stay put where they're at, and we can sentence you as we are doing the hearing here today. That's your choice. Do you know what your preference is about that?
I'm okay with doing it over Zoom.
Okay, now understand, I'm not asking you to do it over Zoom and you saying I'm just okay with it. I'm just asking you,
Yeah.
if you want to come up, there's no problem at all, I promise you. But if you would prefer to do it by video for your own convenience, we can do that.
I'd prefer to do it by video.
Okay, any objection to that, Ms. Goodrich?
No objection.
Mr. Nightingale?
No, Your Honor. Thank you.
Okay, well, you'll prepare a video written then with the department.
Yes.
All right, so we'll schedule your sentencing for June 9th at 10:30 in the morning by video from MDOC.
And Your Honor, the 180 days expires on October 7th. So it'd
Okay,
be
so we're well in advance of that. And I'll dismiss the pending contempts. And Ms. Price, someone from the Department of Corrections may be speaking with you to just write an updated report. So you have to cooperate with them about that. Anything further from the defense,
No, Your Honor. Thank you.
from the people?
No, Your Honor, thank you.
Okay, you're all set, Ms. Price. You have a good day.
Thank you, Your Honor.
I'm sorry. We call, got People v. Daniel Green. File 26-7143 FH. Counsel, you want to state your appearances, please?
No, I look for Mr. Green, who appears in person to my right.
Okay. This is the time and date set for a docket call on a Medicaid fraud case. Where are we at on the status of this, man?
Thank you, Your Honor. So this is sort of a complicated allegations of financial crimes here. We're still actively negotiating as far as the plea is concerned. We request one additional docket call to try to resolve the case.
Okay. Any objection, Mr. Nightingale? I'm sorry, but
No objection to my request.
Yeah, no objection to your own request? Yeah,
Correct.
that'd be fine. Any objection, Mr. Juliet?
No.
All right, June 9th work?
I think that would be enough time.
Yeah.
Okay, we'll put it out to June 9th at 10:20 in the morning.
Would the court consider allowing a Zoom appearance from our client that day?
Any objection, Mr. Nightingale? All right. Oh, my goodness.
Again,
You know, one time I was quoted in the Sheboygan Tribune as saying about the judge's decision that I was going to appeal it no matter what his decision was.
Oh, yeah.
So,
Yeah.
you know, that would be sort of the same thing.
No objection.
No objection, Mr. Juliet. Okay. Okay, I'll allow that then.
Thank you, Judge.
So we're going to continue the docket call to June 9th at 10:20 a.m. Mr. Green, you'll be allowed to video conference in for that hearing if you wish. Be sure that you're in a good space with a good connection, and you can even practice on Zoom if you want. Be in touch with Mr. Nightingale about whether he wants you to be in person or not.
Okay, thank you.
That'll bring us to People v. Felicia Carney. 25-6977. FH, Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
No, not yet from Ms. Carney, who appears on personal custody to my right.
All right, and we're here today for a probation violation hearing. Looks like she was arraigned in late April. This violation in the case was assigned to you. To know how you want to proceed today, Mr. Nightingale?
Well, Judge, we're working diligently to get Ms. Carney into recovery court out of county. I think that Ms. Goodrich was very amenable to having her do it here, but Ms. Carney has wanted to move on from the area and try to start get a fresh start here. And so trying to accommodate that for her. I'm still waiting on some recovery court folks out of county to call me back. So that's sort of where we're at. I do know that Ms. Carney really wants to do that, but she does want to also ask to get released today so she can get her stuff together and get back down there.
Okay, she's looking at Grand Traverse County is where she
Correct.
wants to go. Any objection to that adjournment, Ms. Goodrich?
No objection to adjourn.
What about the issue of pre-hearing release?
Your Honor, my concern is just what I stated at arraignment, that this would be the second new misdemeanor since she's been on probation that she's been charged with, both involving victims before it was on DOP and now it's assault, and then also consuming alcohol while on felony probation for possession of amphetamine. That I think she continues to be a public safety risk, and hoping that with admission to recovery court that would be enough services at once that may help guide her once she's accepted, but until then, I do have concerns.
All right, I think if we could find a recovery court, program that'd be a good fit for Ms. Carney. I don't think I would want to stand in the way of that at all. And at her arraignment, we asked her about, sort of the circumstances of her plan and her situation in Traverse City, and it just seemed too ephemeral for me to feel comfortable with her release. So I guess for me to consider releasing her at this point, since now it's the second alleged criminal violation on probation, I'd want to know, like, what's the plan? Where is she going to be living? What's the status of this job she said she was about to start? I know that it might be difficult for her to suss out some of that information while she's in jail, but I'd want to see a fairly detailed plan that I could have some confidence in, instead of just releasing Ms. Carney and hoping for the best. So at this point, I'll continue her to be held without release. We'll adjourn the probation violation hearing until July 9th at 10:40, or I'm sorry, June 9th at 10:40 a.m. And we'll set that for a status conference on the pending violation. Let Ms. Goodrich know if something changes and you want that, and you intend that to be a contested evidentiary hearing, so she can have folks here. And I guess I'm gonna still order, Felicia, for you to be held without bond. But if you get some details and we have a pretty specific plan about what's gonna happen, then Mr. Nightingale can go talk to the prosecutor. Then he can go talk to the prosecutor, see if they'll agree to it, and if they don't, then he can file a motion, and we can sort that out, okay? But I'm not just gonna release you on a hope. If I release you, it's gonna be on a pretty specific plan, okay? Okay. Thanks. Okay. All right, we can call People v. Jennifer Bird. It's two files, 25-7083 and 25-7085. The 7085 file is going to be dismissed pursuant to plea agreement. We're here for counsel. You want to state your appearances?
No, not Ms. Bird, who appears in person to my right.
All right, and on the 7083, we're here for sentencing on a charge of attempted embezzlement from a nonprofit over $1,000. It's a statutory maximum of 5 years in prison. The advisory guidelines are scored by the Department of Corrections at 0 to 6 months. I have had a chance to review the pre-sentence report as well as a couple of victim impact statements. Mr. Nightingale, have you had a chance to review the pre-sentence report with your client?
Have your honor, finding no errors or omissions as far as the pre-sentence report is concerned. Would request at this point to adjourn today's sentencing for a few weeks. Ms. Bird does have her twins that are graduating from high school next Friday. Obviously she does not want to miss that. And, I think further, her children don't want her to miss that. I understand that. I think that she understands that there's going to be some consequences here that she's going to have to pay, both literally and figuratively. But I'm just not sure the damage that does to the kids, and I don't know if that's they are innocent parties here. And I would request that she be allowed to come back in a few weeks for the sentencing further. I was hoping to get some letters from her therapist and her doctor. I have not received those letters yet, and so for those additional reasons, would request an adjournment of today's hearing. I think the court would like to consider those letters as a part of today's sentence.
Thank you, Mr. Juliet. People's position.
I would object, I guess, for two reasons. One, several victims here that want to address the court. Two, this has already been here a few times, I believe. So it's time to move forward today.
If I could respond to that.
Yeah.
So, of course, no objection to having anybody that wants to address the court today, so they do not have to return. I understand that that's an inconvenience to them, and would not obviously object to them having their statements read into the record today for purposes of sentencing. Further, I don't believe that we have requested an adjournment.
No, they were adjournments by the court, or by one was by the court and one was by I think blizzard emergency.
Correct. And so this is our first request for an adjournment of today's sentencing hearing. So I just want to be clear about that.
All right, thank you. Well, in terms of the letters, I mean, even though they weren't defendants' requests for adjournments, it has been adjourned now almost 2 months from the original sentencing. The plea was entered back in early February, more than 3 months ago. So there would certainly have been sufficient time for the defense to present any information they wanted me to consider by today. So that's not a reason for an adjournment. And also the fact that her kids are graduating from school and the kids are going to be sad. And in addition to Ms. Bird, of course, being sad about missing that. I guess what I'd say about that is that lots of the people that we sentence in this court, there are collateral consequences that are negative that flow into their family as a result. There are lots of important life events that people miss when they commit felony crimes. And that's just a fact. It's not a fact I take great pleasure in, but if I were to adjourn Ms. Bird's sentencing so she can attend a graduation, I'd owe an apology to an awful lot of people that I've caused to miss an awful lot of things for the cases that they had. So I'm going to deny that request, and we're going to go forward with sentencing today.
And there it is, the adjournment denied, the judge's reasoning. Blunt, fair, and frankly unforgettable. There are lots of important life events that people miss when they commit felony crimes. That line right there is the judge drawing an equity line. If I delay sentencing for one defendant's family milestone, I owe an apology to everyone I've ever sentenced whose family missed something too. This is judicial consistency in real time. Now the Bird sentencing moves forward. A 49-year-old woman, no prior criminal history, trusted with nonprofit finances, and a gambling addiction that quietly spiraled into over $51,000 embezzled. The defense argument: keep her out so she can pay it back. The problem: the judge just flagged. She's not even working right now. This is about to get very interesting.
With that, Mr. Nightingale, do you have any scoring challenges to the 0 to 6 guidelines?
No, Your Honor.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
Your
Mr. Nightingale, anything you want to say on behalf of your client? Go ahead.
Yes, Your Honor, thank you. So Ms. Bird comes before the court at 49 years of age. She has, up until this point, absolutely no criminal history, no prior felonies, no prior misdemeanors. She obviously was in a position of trust here with multiple nonprofit organizations in the community. It sounds like she had been in that position for some time, and unfortunately developed this nasty gambling habit. She made a series of poor choices, and I know that the court's going to probably emphasize, the series of choices rather than just the one. And I think for most people, they make the first choice, and it doesn't seem that bad, right? They don't get caught, nobody really even notices, and it becomes this really slippery slope for folks.
They often have an intention to pay it back, and they get behind on it.
Right, and
that's a fairly common pattern. Yeah.
Correct. And so I think that Ms. Bird has definitely fallen into this pattern where she intended to make this right, and just got to the point where she was way behind the 8 ball. And when I sat her down for the first time to talk to her about this, was shocked at the figures that we were talking about. When we're talking about, $200 or $600, those don't seem like a lot of money, but then you add them up, and we get to this big amount here. And I don't think that Ms. Bird realized how deep she had gotten herself into this situation. Thankfully, this was put a stop to, right? And unfortunately, some folks, particularly the Malt Lake Area Preservation Society, bore the brunt of her poor choices here. And I know that this issue has garnered some attention in the community. I think that's maybe an understatement at this point, but nonetheless, people are very aware of what's going on here. I think that folks are probably watching this on YouTube and realizing, that you just cannot make these choices. I mean, this is a very small place. People are going to find out, and it doesn't matter if you had the intention to pay it back or not. Nonetheless, we are still here. What I would draw the court's attention to specifically is that Ms. Bird has no criminal history up until this point. That these are a series of choices that she very much wishes that she could take back, but unfortunately have not invented a time machine just yet. Judge, she's going to have certainly some pain today that she's going to experience. She's going to have some pain for the future that she's going to experience. We have offered and agreed to pay back both restitution amounts. What I think the court should also know is that, Ms. Bird is adamant that there was no wrongdoing with the Chamber of Commerce. The amount for the chamber is like $2,000, give or take some money. That appears, at least from defense perspective, to be legitimate reimbursements that people kind of just forgot that they signed the check for. Whether people agree with that or not, that's not our position, right? But at the end of the day, she's agreeing to pay it back because it's the right thing to do, and she wants to clear that suspicion. So we're going to agree to pay it back, and we have. I think the bigger issue, right, is the Malt Lake Area Preservation Society, $51,726 we agreed to pay back to them. I think it's clear that when folks are in jail or serving a sentence of any kind, they cannot be working and they cannot pay back restitution. And it is our perspective and position that the most important thing here is to pay these folks back and to atone for those actions in that way. Obviously, if Ms. Bird is sentenced to jail or prison today, she cannot, for the foreseeable future, make this right. I don't know how much time the court is considering, if the court is considering time at all. But that would be at the forefront of our perspective, that the more she is able to work and the quicker she can get back, the quicker these folks can be made whole. And I think that's the point of this entire exercise at the end of the day. Of course, another component of the exercise is to make sure that people don't do this stuff in the future. And so she understands that she's gonna have.
She's unemployed today, right?
Yes. I mean, part of this is that it's hard to find a job with pending felony cases.
Okay, but so she can't go to jail because she needs to work and pay it back, but she's not working. I just want to make sure I understand that.
That is correct at this point, yes, Your Honor. Further, she's also seeing a therapist and a psychiatrist here. We were going to provide letters. Unfortunately, we don't have those today. But she has been diligently seeing those folks for a matter of months, working through these issues as far as her gambling thing is concerned, what brought her to this in the first place. Like I said, Ms. Bird is 49 years of age, and the court has not seen her in this capacity, not just this court, but any court. And so I am confident that as long as she continues to work on herself, that this is not going to happen again in the future. She's obviously not going to be put in a position of trust like this with any nonprofit organization in this county or the state, or frankly, the United States at this point, but with this kind of prior felony. But nonetheless, she can still be gainfully employed in the future. She can still continue to work on herself. She can continue to take care of her children and to be, a good member of the community. I know that she had a significant slip up here, and this is going to be hard earned for her to get this back. As I say all the time on the record here, this is a very small place, and people know you before you even open your mouth. And so this is going to follow Ms. Bird for the rest of her life, no matter what the court decides to do today. We would just ask the court to stay within the guidelines. Her guidelines are 0 to 6 months. I cannot think of a compelling reason to deviate from those guidelines other than just to punish Ms. Bird. And that is not, in my mind, the most important thing here. The most important thing here is to make these folks whole. And so we're asking to have the court sentence her to incarceration within the guidelines. We're asking the court to put her on probation. That is the recommendation of the probation department. She's willing to do the max term of probation. She's willing to pay this back. And so that's what we're asking for today.
Thank you, Mr. Minky. Ms. Bird, you don't have to make a statement today, but you're welcome to. Is there anything you want to say or no?